The closing paperwork was still being processed at the title company on Meridian when my brother's wife posted a photo to Instagram. I was sitting in my car in the parking lot across the street when the notification came through. Her account was public, which she had never thought to change after I quietly unfollowed her 2 years earlier. The caption read, "New chapter." With a picture of the two of them in the lobby, my brother's arm around her shoulder. Both of them wearing the particular smiles of people who believe the difficult part is finally over. I looked at the photo for a long moment. Then I put my phone face down on the passenger seat and watched through the windshield until the glass doors of the building opened and they walked out together. My brother tucking a manila folder under his arm with the easy confidence of someone who has just done something he has been planning for a very long time. What he didn't know was that I had been planning longer. I need to explain what the 14 months before that parking lot looked like, because the scene only makes complete sense once you understand what it cost to reach it. My mother's diagnosis came on a Wednesday in late October. Mild cognitive impairment with what her neurologist described as a moderate conversion risk, which is a clinical phrase for what she has will likely become something worse. She was 63. She still drove herself to her Thursday book club. She still made her lemon pound cake from memory every Sunday without consulting a single measurement. But she had begun losing words mid-sentence in ways that startled her. She would stop, touch the side of her face, and apologize for something that was not her fault. She misplaced her keys in the refrigerator twice. She missed utility payments she had never missed in 30 years of managing the household alone. Her neurologist said that a stable, low-stress environment and consistent daily support were among the most protective factors available given her trajectory. My brother, who lived 40 minutes away in a newer development with his wife and 2 labradoodles, nodded carefully during this appointment. He asked several questions that had the shape of concern. He took notes on his phone. "I am a mortgage loan processor. I have spent the last 6 years at a regional lender in Clarksville, and the 2 years before that at a title company, learning how real property transactions actually work. Not the simplified version, not the version a listing agent explains over appetizers, but the document-level version. The one that requires you to understand what a notary acknowledgement legally means and when it can be validly executed and what specific defects render it void and unenforceable. It is quiet work. It is the kind of work that makes dinner table conversation difficult. Because the moment I start explaining what I actually do, I can see the moment people stop listening. But it meant that when my brother began circling the topic of my mother's house approximately 3 weeks after her diagnosis, using phrases like protecting the asset and avoiding probate and keeping things simple for her sake, I understood precisely what kind of conversation we were really having. My mother's home is a 4-bedroom craftsman in the Germantown neighborhood of Nashville. My grandmother purchased it in 1971. My grandfather laid the kitchen tile himself over a long summer. My mother inherited it outright when my grandmother passed, and it sits on a corner lot that a local development group has been quietly eyeing for the better part of a decade for a mixed-use project. My brother had always known its value. What the diagnosis gave him was a deadline and an argument. I moved into my mother's spare bedroom in early November. This was not a difficult decision for me, though my brother acknowledged it as a sacrifice several times in the weeks that followed, using the word with the deliberate care of someone making a deposit they intend to withdraw later. I enrolled my mother in a cognitive support program at Vanderbilt Medical Center. I took over her medication management, coordinated with her primary care physician, installed grab bars in the main bathroom, and set up a smart lock on the front door after she came home one afternoon to find she had left it standing open since morning. I restructured my remote work schedule around her routines. My brother visited approximately every 3 weeks. His wife joined him on roughly half those visits. Their standard contribution during these Sunday appearances was to sit in the living room asking my mother about her childhood, while I finished preparing whatever I had planned for dinner, after which they would mention a prior commitment and leave before 7. My brother introduced the house conversation for the first time in January. He framed it as a practical question. The way people frame things when they have already reached the conclusion and are working backward. Had Mom thought about long-term care? Was staying in the house realistic given her trajectory? He had toured a memory care facility out in Brentwood. Really lovely gardens, he said, just worth knowing about. My mother told him she was not going anywhere. He nodded and said of course, and refilled his coffee. The second conversation came in March. He brought a folder. It contained printouts about Tennessee probate costs, articles about families damaged by estate disputes, and a document he described as a simple quitclaim deed that would transfer the house into joint tenancy between himself and our mother with right of survivorship, meaning that if anything happened to her, the property would pass directly to him without going through probate, quickly, cleanly, without any court involvement. He presented this as something he had arranged for her benefit. He said it had been drafted by his own attorney. He said there was no pressure, but that sooner was generally better given her situation. He said the word situation the way people say it when they want to acknowledge something without naming it. I asked whether my name would also be on this joint tenancy. There was a pause that ran about 2 seconds longer than it should have. He said his attorney had recommended keeping the title simple. One name was cleaner from a legal standpoint. He said I would be taken care of through the rest of the estate. He said this while looking at the folder rather than at me. That night, after he and his wife had driven back to their development, I sat at the kitchen table with my laptop open and pulled up the Davidson County Register of Deeds online portal. It is a public database. It requires no special access. I entered my mother's address into the search field. A quitclaim deed had been recorded 11 days earlier. I read the document 4 times. The grantor was my mother. The grantee was my brother, sole and separate property. The stated consideration was $10. The notary acknowledgement listed a date 3 Saturdays before the recording. I recognized the notary's name immediately. My brother had mentioned him once in passing, a man from his Thursday morning golf group, someone who handled the occasional closing for people in his neighborhood. The acknowledgement stated that my mother had personally appeared, identified herself, and executed the document of her own free will. I have processed enough loan packages to know what a valid notary acknowledgement legally requires in this state. The notary must be commissioned and active. The grantor must appear in person. When a grantor carries a documented cognitive diagnosis, the circumstances surrounding a signature carry substantially more scrutiny, not less. I printed the document and set it on the table next to my water glass and looked at it for a long time. I did not call my brother. I want to be honest about how much self-control that required. What I did instead was call my mother's neurologist's office the following morning and request that a formal capacity evaluation be added to her existing file. I explained that her primary residence was the subject of a recent property transfer, and I wanted a contemporaneous record of her cognitive status from the approximate period in which it occurred. The psychologist had availability the following Thursday. I drove my mother to the appointment and sat in the waiting room with a year-old magazine while she completed the standardized assessment. The resulting notes, which I later obtained with my mother's signed authorization, concluded that her executive function and working memory scores were consistent with moderate impairment in high-stakes decision-making contexts. She was, in the psychologist's documented language, vulnerable to undue influence. The notarization date fell squarely within that assessment window. I spent 2 evenings working through what I had accumulated, sitting at the kitchen table after my mother went to sleep with her medication sorted and the door locked. The deed was recorded and existed as a legal instrument. Contesting it would require establishing either that my mother lacked the legal capacity to execute it, or that the notarization itself was defective, or both. I was not an attorney. But I was someone who understood real property documentation in a specific and practical way. I called a woman named Rosalind the following Monday. We had worked at the same title company years earlier, before she had moved into an elder law practice across town. I asked if I could buy her lunch. She looked at everything I had brought in about 45 minutes and identified 2 problems I had not yet caught. The first was significant. The notary's commission had lapsed 14 months prior to the deed's execution date. He had failed to renew his state certification. Any acknowledgement he had executed during that period was legally invalid from the moment it was stamped. The second issue was a minor but documentable discrepancy in the deed's legal description. The lot dimensions did not precisely match the recorded plat, an error that would surface the moment anyone attempted to convey or encumber the property. Rosalind said she could refer me to a colleague who handled elder financial exploitation cases. Tennessee had a specific statute covering exactly this category of conduct. The available remedies, she said, were not gentle. I told her I would be in touch. On the drive home, I stopped at a pharmacy near my exit and purchased a small digital voice recorder. My brother had left a voicemail that morning asking to schedule what he called a family meeting to go over some additional documents for my mother to review. He said it would be straightforward. I texted him that Sunday worked. I charged the recorder overnight. I tested it in the kitchen, the living room, and the hallway to confirm audio quality across the distances I might need. I placed it in the interior zip pocket of the cardigan I planned to wear. I practiced activating it without looking at my hand. Sunday arrived gray and cold. My brother came with his wife and a fresh folder. He mentioned that his attorney was available by phone if anything complicated came up, which he said with the tone of someone who did not expect anything complicated. My mother sat in her usual chair at the kitchen table, the chair she had occupied for 30 years, and looked at the documents he placed in front of her with the careful, slightly distant expression of someone who understands they are being guided through a process but cannot quite locate the map. The new document was a financial power of attorney. Broad authority over my mother's accounts, he explained. Standard language, just a formality, purely for her protection given her situation. He said situation again. I asked what the scope of his decision-making authority would be under this document. He said it was drafted broadly to be useful. I asked my mother if she had seen this before today. She said she had not. My brother said that was fine, that was why they were here, so she could look at it now. I said I had a question first about the quitclaim deed already recorded against the property. I asked when exactly my mother had signed it. He said late February, that they had handled it together. I asked if my mother remembered that signing. She looked at me with an expression I recognized. The expression she wore when she was trying to locate something she knew she should be able to find. My brother said I was upsetting her. He pushed the POA document a few inches closer to her on the table and said it just needed her signature. It would take less than a minute. I said I thought my mother should have her own attorney present before signing anything further. He said she did not need an attorney for a family matter. I said that given her documented diagnosis, any instrument she executed without independent counsel and a contemporaneous capacity evaluation would be subject to challenge on undue influence grounds, and that I had already spoken with an elder law attorney, and that if that document moved any closer to her hand, I would be on the phone with that attorney within the hour. The kitchen was very quiet. His wife said my name in the careful tone people use when they want someone to be reasonable before things become irreversible. My brother said I had always had a problem with him specifically, and that this was not about protecting our mother, it was about my own issues, which was a sentence I had been hearing in various forms since I was 12 years old. He said it with the ease of long practice. I said that was possible, and that it did not change the fact that the notary whose name appeared on the recorded deed had held a lapsed commission at the time of execution, and that this was documented in the state's public licensing database, and that I had already obtained a certified copy of my mother's capacity evaluation from the same period, and that Tennessee Code Annotated Section 71 to 6122 covered financial exploitation of vulnerable adults with remedies that extended beyond the civil courts. He picked up the POA document and put it back inside the folder. He and his wife left 40 minutes later. She did not say goodbye to my mother. My brother paused at the front door and told me I was going to regret the way I had handled this. He said it quietly, the way you say something you intend as a statement of fact rather than a threat, though the distinction matters less than people think. What he did not know, because I had not said it and had no reason to say it, was that the conversation had already extended well beyond that kitchen. The Wednesday before that Sunday meeting, I had spent an afternoon with Rosalind's colleague, an attorney named Mr. Merzelin's colleague, Garrett, reviewing the full documentation I had assembled, the recorded deed, the printouts from the state notary database confirming the lapsed commission, the capacity evaluation with its dates and clinical language, and a written statement from my mother prepared during one of her clear mornings with Mr. Garrett present, describing what she believed she had been signing when she put her name to the document in February. She had believed she was signing a renewal form for the homeowner's insurance. My brother had told her it was something the insurance company required. She had not read it carefully because he had told her it was routine, and she had trusted him the way mothers trust the children they raised. Mr. Garrett had filed the quiet title action the Thursday morning before that Sunday. The filing was already in the system before my brother arrived at my mother's kitchen table with his folder and his attorney available by phone. He had come to collect a second document without knowing the first one was already being contested in Davidson County Chancery Court. He learned about the filing the following Tuesday. His own attorney called him. I was not present for that call, and I did not need to be. My mother mentioned that evening that Marcus had called her by accident earlier in the afternoon, and then hung up very quickly when she answered, and that he had sounded strange. I said I was sure he was fine. The legal proceedings took several months. My brother retained a real estate litigator, which cost him considerably more than he had calculated for. The quiet title action succeeded on the narrowest and cleanest grounds. The lapsed notary commission rendered the acknowledgement void on its face, which meant the deed itself had never been legally effective as a conveyance. The capacity documentation entered the record as supplementary evidence. The judge ruled in my mother's favor. The deed was vacated. The title reverted cleanly to her name, where it had always belonged. Mr. Garrett also filed a separate complaint with the state licensing board regarding the notary. Whether my brother had known about the lapse when he arranged the signing, or whether it was a convenient carelessness he had not bothered to check, I cannot say with certainty. The licensing board's inquiry did not require my certainty. Tennessee Adult Protective Services opened a parallel review after we filed the report. My brother received a letter from the state that I was not entitled to review, but whose arrival I heard about from my mother, who mentioned it one morning at breakfast with the mild confusion of someone who had received mail she didn't understand. She said she thought there was something from a state agency for Marcus. I told her I would help her figure it out when she was ready. I want to be precise about what the months after the ruling actually felt like, because I think the story is easy to read as cleaner than it was. My brother and I have not spoken since the Sunday meeting. He sent a single communication through his attorney proposing a structured resolution to what the letter called the ongoing family matter. Mr. Talpover-Takin. Garrett reviewed the terms and told me I was under no obligation to accept them given the court's ruling. I did not respond. A follow-up letter arrived 3 weeks later. I did not respond to that either. At some point the correspondence stopped arriving and I noticed its absence, the way you notice when the sound you had grown accustomed to finally goes quiet. What was more complicated than the legal outcome was my mother. She understood what had happened in pieces, and differently on different days. Some mornings she was entirely clear. She would say Marcus did something wrong with the house, didn't he? And I would say yes, and she would nod once and look out at the yard and not say anything more about it. Other mornings, she would ask what time Marcus and his wife were coming over, with the uncomplicated warmth of someone whose memory keeps restoring her love before the injury has had time to re-register. On those mornings I would say I wasn't sure about his plans and I would turn on her favorite program and she would stop asking within a few minutes because the baking competition had started and she liked watching the technical challenge. Grief and relief are not the same feeling and they are not mutually exclusive. A therapist I saw twice told me this and I found it more useful than most things I paid for during that period. You can miss the brother you thought you had and also be profoundly grateful that you looked at the public records when you did. The two things live in the same house without resolving each other. I am still in the spare bedroom. I rearranged my remote work schedule with my manager's help, which she accommodated without hesitation because I had not asked for flexibility before. A cognitive support specialist comes on Tuesdays and Thursdays now. A woman my mother has begun to genuinely like. I repainted the kitchen in April in the soft green my mother had been planning to get to for 4 years. She had the paint chip folded in her junk drawer when I found it, a square of color she had been carrying around as a plan she kept meaning to execute. When I finished, she stood in the doorway for a long moment and said, "Oh, that's exactly right. It was a good morning." I have been collecting the good mornings carefully, the way you collect things you know are not guaranteed. What I keep returning to, more than the deed or the court ruling or any specific document, is something much smaller. The notary's lapsed commission was sitting in a public database. 12 minutes with a search field and an internet connection. That's what was standing between my mother and a fraudulent transfer of the home she has lived in for 30 years. 12 minutes? And the assumption on my brother's side that I was too occupied with the daily labor of caretaking to look. He was not entirely wrong about the being occupied. He was completely wrong about what I do with it. There is something I've been thinking about since the ruling, and I want to ask it plainly because I believe it matters beyond this specific story. Caretaking has a way of becoming invisible to everyone except the person doing it. The medication schedule. The doctor appointments. The repainting. The 3 o'clock mornings when your mother wakes up uncertain of where she is and needs a familiar voice to bring her back. That labor tends to get categorized by the people who aren't performing it as something the caretaker chose, something personal, something that doesn't generate the kind of weight that deserves acknowledgement or protection. And the person doing it, after enough months, begins to half believe that categorization too. Begins to wonder whether asking to be seen is the same thing as asking for too much. I was useful to my family in a way that made me convenient to route around. I was close to the situation. I was distracted by it. I was, they assumed, too embedded in the daily care to be looking at anything else. Here's what I want to ask you, and I'm asking it as a genuine question rather than a tidy conclusion. If the person who should have been beside you, protecting the same person you were protecting every day, was instead quietly constructing a case against everything you had built, while you were managing the morning medication and the Thursday appointments and the paint chip someone had been saving for years, how long would it take you to look up from the work and check the public records? And when you looked, what would you find?